In Nevada, like in other states, there are three parties involved in workers' compensation matters. That would be the injured worker, their employer, and the employer's insurer for workers' compensation, unless the employer is self-insured, in which case that third party would be an administrator of their self-insured program of workers' compensation insurance. And in Nevada in particular, all three parties are subject to litigation with respect to any number of issues that can arise in a normal workers' compensation claim. The first, of course, is claim acceptance and the injury itself. The injured worker, if there's any doubt with respect to the injury, is going to find himself litigating what is supposed to be a no-fault insurance system, but he or she will find very quickly that the litigation that they're involved in requires them to have counsel. And in Nevada, we do have a free counsel for injured workers under the Nevada Attorneys for Injured Workers. For employers and insurers, however, they must rely on private counsel. And although insurers are aware of their need for and the necessity for counsel with respect to workers' compensation litigation, employers often are not. And they do not get counsel at a high risk, it appears to those of us who regularly litigate workers' compensation matters. For example, in a claim acceptance situation, the employer has key knowledge with respect to what happened on any given day to any given employee. On the other hand, the insurer is often just relying on information that it gets secondhand when it makes its decisions. And when litigation occurs with respect to whether an actual injury occurred on a given date at a given time at a given place, if the employer is not involved in that litigation and just depends on the insurer, maybe all the facts may not come out, and it may well be to the negative effect of the employer. That's why I always counsel employers to get litigation counsel with respect to their workers' compensation litigation.